Mr. James Hatuikulipi, on different occasions, he get a total of 380,000 Namibian dollars. And the 150,000 was paid to Greyguard Investment CC, a company owned by Mr. James Hatuikulipi. Greyguard Investment CC paid that amount in the same total to Irongo Clearing and Forwarding CC, a company owned by Thompson Hatuikulipi. Then Thompson Hatuikulipi, upon receiving such amount, he wrote out a check to the same amount of 150,000 Namibian dollars. In respect of Mr. Bernard Esau, who was by then a Minister of Fisheries and Marine Resources. Investigation further unveiled that several meetings were held in Angola and also in Iceland. The meeting in Angola were conducted as from the 15th until the 22nd of January 2014. And this meeting, I can recall Mr. Johannes Stephenson attended, Mr. James Hatuikulipi attended the meeting, Mr. Saki Shangala attended that meeting, and Mr. Thompson Hatuikulipi also attended the meeting, as well as Mr. Ricardo Gustavo. In this meeting, they were all representing a company known as Nangomar. And it was indicated that they were representing it on the Namibian side. Another meeting was held in Iceland. This meeting was between the 20th and the 23rd of August 2014. In this meeting, Mr. Saki Shangala did attend. James Hatuikulipi did attend. Thompson Hatuikulipi did also attend. And Mr. Ricardo also did attend. In these meetings, in the meeting in Angola, one of the issues that was being discussed was the establishment of a joint venture between Namibia and Angola. And the other thing that was discussed was as to how the payments should be done in case the quotas have been allocated. As per information provided in Mr. Johannes Stephenson's statement, he indicated that during the meeting in Iceland, Mr. Saki Shangala made a presentation on what was called the Nangomar project. And it was also at the same meeting where Mr. James Atuikulipi, Mr. Johannes Stephenson, and Mr. Tolstein of the Samiri Group decided that if quotas have been awarded to the company that we came to know as Nangomal Pesca SA, the 75% of the usage fee should be paid abroad, while 25% of the quota should be paid in Namibia. While in Iceland, Mr. Ricardo Gustavo entered into an agreement with the Samiri Group, which is termed as a catching agreement. This agreement was entered into between Asia Holding, which is a Samiri Group company, and the company known as Corporate Investment Pty Ltd, which was now trading as Nangomar. In such agreements, the usage fee that with regarding to the catching of the quotas that should be paid in respect of that agreement was an amount of 500 Namibian dollars per metric ton, which is regarded to be low by that time, as other agreements entered into. The usage agreements were up to 3,000 Namibian dollars.
Is that per metric ton?
Yes, per metric ton, yes. In meetings held in Angola, as per documents submitted by Mr. Stephenson, there is also an indication that Mr. Saki Shanghala also did a presentation on what was termed Opportunity Angola. And there was also a meeting that Mr. Thompson Hatuikulipi did attend with the Minister of Fisheries in Angola, Ms. Victoria de Barros. It was done in the same trip. We also obtained some email correspondence with regarding to how the money should be paid, the 75% and the 25%. Our investigation revealed that, as I mentioned, that by that time, the Minister of Fisheries and Marine Resources was not having power to give quotas to the non-right holders. The accused persons came up with what was termed as a bilateral agreement, or they agreed that a bilateral agreement should be entered into between the two countries, between Angola and Namibia, And this bilateral agreement, as per the information, it was initiated by Mr. Saki Shanghala. By that, Mr. Saki Shanghala was the chairperson of the Road Reform Development Commission of Namibia. There was a draft agreement that was drafted for that purpose of entering into agreement by the two countries. And before such agreement was entered into, a draft agreement was submitted to the Office of the Attorney General. By that time, Dr. Albert Kawana, for scrutiny. He scrutinized the draft agreement and he gave his advice that the Angolan government, since they don't want to enter into a binding agreement, they rather prefer a non-binding agreement. Hence, he downgraded such bilateral agreement to the Memorandum of Understanding. That Memorandum of Understanding was then entered into. It was very broad when coming to the utilization of the quotas or the caching of the quotas, as there was no any legal obligations from any party, either from the Angolans, either from the Namibians. And there was also no indication as to how much quotas can be caught during a certain financial, a fishing season. Yeah. As they were advised that rather they should enter into a memorandum of understanding. The memorandum of understanding was entered into on the 18th of June 2014, which was signed by Mr. Bernard Esau, as a Minister of Fisheries and Marine Resources in Namibia, and Ms. Victoria de Barros, as a Minister of Fisheries in Angola. Now, following such agreement, a company known as Nangomal Pesca SA was appointed to get quotas based on that agreement entered into. Nangomal Pesca SA, as per the information provided, this was supposed to be a company in Angola, but as per statement given by Mr. Pedro, the head of Interpol in Angola, the investigation was carried in regarding to such company, and it was established that Nangomal Pesca SA is a non-existent company in Angola. Although, based on that agreement, this company was awarded quotas on several occasions, totaling to 50,000 metric tons. The quotas were awarded by the minister, Mr. Bernard Esau, who by then the Minister of Fisheries and Marine Resources.
Did I hear correct? Is it 50,000 tons or 50,000 metric tons?
Metric tons.
50,000 metric tons.
Yes, correct, my lord. Okay, the value of these 50,000 metric tons if we follow the agreements, other agreements which were signed during the time these quotas were allocated, and where the usage fee is agreed as 3,000 Namibian dollars, the value of these 50,000 metric tons could be 150 million Namibian dollars. Investigation further revealed that this allocation of quotas, or the quotas allocated to this Nangomal Pesca SA, are quotas that the ministry gave for governmental objectives, which were supposed to benefit or to be utilized in the interest of the public. But what was revealed during the investigation is that when the Sameri group was make payments with regard to these quotas, they were making payments to a company or to the account of a company known as Nangomal Pesca Namibia. This Nangomal Pesca Namibia is a company solely owned by all. The only director in this company was Mr. Ricardo Gustavo. And the shareholder in this company was a company in Angola, a company known as Nangomal Pesca Limitada. And as per information provided, two companies, of which one belongs to, or the Ministry of Fisheries in Angola is having interest. They were members of this, the shareholders of Nangomal Pesca Limitada. So this company is Jovibal and the other company is Tamaku. As I indicated, that the Nangomal payments, or the payments of the quotas were made into this Nangomal Pesca Namibia Pty Ltd. These payments were further distributed to companies in which the accused persons are having interest. I can recall the company of Grey Guard Investment, CC, the company of Mr. James Hatwikulipi, the company of known as Erongo Clearing and Forwarding, CC, the company of Mr. Thompson Hatwikulipi, GT Trading is also a company of Thompson, and Otafika Logistic, a company owned by Mr. Pius Matelulu. As per the analysis conducted on the bank statement of Namgomal Pesca Namibia, a total amount of more than 38 million were deposited into this account by the Sameri Group.
In which account?
In the account of Nangomal Pesca Namibia, Pty Ltd. Although such amount was received in this account, investigation conducted by Inland Revenue or officials from Inland Revenue who were also part of the task team on this investigation, they revealed that only 9 million was declared by Nangomal Pesca Namibia. The investigation further revealed that, as I said earlier, that there was an agreement between the accused persons that some of the money should be paid abroad, which was also agreed by the representative of the Sameri Group. Information received from Norway with documents provided indicated that an amount of 4.1 million was deposited in an account of a company known as Tundavala Invest Limited.
Okay, just hold on. That 4.1 million, what currency is it?
The 4.1 million is in American currency, US dollars. Okay, this payment was made into the account of a company known as Tundavala Invest Limited, a company which came now to know as being belongs to Mr. James Atuikulipi. These payments were made after Tundavala invoices were presented to them. These invoices were presented to Asia Seafood and Noah Pelagic. Those are some of the Sameri.
May I just, which year was the 4.1 million made, and what was the exchange rate at that time? So if you convert it into Namibian dollars, how much, what will it translate into?
I think this payments was done between 2015 2019, but I cannot really give as to what was the exchange rate during that time.
Okay.
All right. You ended where you said that Tundavala invoices were presented to Asia Seafood and Noah Pelagic.
Yes, correct.
Two?
He said Asia Seafood and Noah.
Asia?
Yes.
Asia.
Asia.
ESJA, Seafood.
Yes, okay.
And Noah Pelagic.
Noah?
Yes.
Noah, the ark, the biblical ark.
Yes, my lord.
Okay.
When such transactions were detected or were revealed, during the investigation, There was a mutual legal assistance request that was sent to Dubai or to the United Arab Emirates through the Ministry of Justice for them to provide us documentation regarding that account. But so far, we did not get any positive response to them, since they are not cooperative. So we cannot now see as to how the money was moved from that account, if it was moved, or whether the money is still there, of which we possibly believe it is there. During the arrest of Mr. James Atuikulipi in Saki Shangara, there were some cell phones that were seized during the arrest. And the cell phone of Mr. James Atuikulipi was analyzed by one of our investigator analysts, Mr. Wycliffe. When he analyzed such cell phone, some information were retrieved from that cell phone. And that information was related to the payment of 500 Namibian dollars per metric ton, which was now paid by Nangomal Pesca SA, which was receiving quotas, or by the Sameri Group, which entered into an agreement with Print. In that information, Mr. Atuikulipi also was asking a certain Mr. John Olafson to create some invoices in the name of Nangomal Limitada, which is an Angolan company, to depict the amount which was agreed upon as if they were invoiced. This amount I refer to is the amount that was paid abroad, the 75% agreement. They want to cover that gap. He said they have to he indicated they have to create to cover the gap of 500 Namibian dollars to make out an invoice of 1,500 Namibian dollars per metric ton, which means by that it is an indication that the quotas they agreed upon was 4,000 Namibian dollars per metric ton. So when Mr. Olafson made queries with James whether this creation of the papers or of the invoices will not be detected if the issue is to be investigated. He indicated to such person that the investigators is not having that capacity of investigating foreign bank accounts or offshore accounts.
Who was saying that?
Mr. James. So, for this message, there is no evidence to say that there were invoices created, but there was such a request. Okay, investigation further revealed that this money that the accused persons or their entities received from Nangomal Pesca, Namibia, this money was never used for governmental objectives as per the quotas given by the Ministry of Fisheries and Marine Resources.
I just clarity. Remember, you mentioned two amounts. There's a 38 million and a 4 million US dollars. So when you say investigation further received that the amounts paid to Namgomar, which amount are you referring to? The 38 million? Or are you
referring to the 38 million, my lord.
Okay.
The money was not used for government objectives, but it was rather used by the accused persons to buy assets, to loan to each other, and to construct and to acquire properties for themselves.
Okay. You also referred to the shareholder of Namgoma Pesca Namibia as being an Angolan entity. What can you tell me about any payments to that entity, to the shareholders?
The shareholders of Nangomal Pesca Namibia, who is now Nangomal Pesca Limitada in Angola, as per documentations or as per bank statements obtained from the banks, in their analysis conducted, there is no any indication of any money coming from Nangomal Pesca Namibia to Nangomal Pesca Limitada.
Insofar as this case is concerned, for purposes of these bail hearings, have you prepared a bundle for the court to consider? The
There are
evidence gathered.
some bundle of documents that prepared for the purpose of this bill.
Okay. Okay, you can choose this one. Do you have one bundle for the Namgoma that you are referring to?
Yes, I do have one.
There's no issues of disclosure here.
We provided the bundles to all the parties, Your Lordship.
Everybody has a copy.
Yes, Your Lordship.
We confirm that.
Your Lordship, I'm informed that there's a request from one of the applicants for a bathroom break, for a short break.
Yeah, because it's, according to my watch, it's 15:34.
Or should we adjourn?
Okay, it's maybe a health break. With a health break, otherwise I'll need to have cleaners all over here. Yeah. So if we can take an adjournment,
As it
5 minutes or 10 minutes, we come back, and even if it's just 20 minutes, then we break tomorrow.
as a pleasant.
All right.
Do you have that file before you?
Yes, I have the file.
And what is contained in that file?
The file contains documentations, which includes emails, reports from Deloitte, and some documents that were obtained during the course of the investigation.
Can you just briefly take us, starting from the first page, what is contained thereon, and then you can move on?
What contains on the first page? This is an email from James Atuikulipi, dated 28 February 2012, to Mr. Ricardo Gustavo, copied to Johannes Stephenson, with the subject Angola opportunity. And there is an indication that there were some attachments on the email. And the email read as follows. Following our breakfast meeting this morning, we discussed to explore fishing opportunity in Angola. This email have copied Johannes, who is the business development manager for Katla in the region. He is currently involved by making sure that the vessel that arrived in Namibia waters yesterday can start fishing. I have attached the profile of the group for your information. Please feel free to engage both of us directly.
Okay. And on the next page?
On the next page, there is an email indicated to be from Sakios Edward Shanghala, dated 28 July 2013, directed to Johannes Stephenson, Asia Fishing, with the subject Opportunity Angola, and there were also attachments on the email.
Okay. What does the first line of that email say?
The first line, on
The paragraph itself.
in the paragraph it said, you may notice that I am corresponding to you directly without consulting James and Fiti as yet.
Oh, okay. In your investigations, have you established who this Fiti is?
Fiti is Thompson Hatuikulipi.
Your Lordship, as the court considers numerous documents which are before court, we don't want to have a situation where each and every document has to be read the whole paragraph. So I think it's going to be quicker and easier. We all have the document before us. We know the entire content of the document. If there is a need for the entire content to be read, that can be raised by the parties. I think for the time being, it will be quicker if we just refer to the relevant portions. He can comment on those, then we move on. But if there's a need for the entire document to be read, then that can be raised at any stage, Your Lordship. I think this might also save us time when going through these documents.
Mr. Soni?
My Lord, my only concern is the question of what will be on record. If my learned friends are quite happy to place certain things on record, then that is all that will remain on record, and it won't be open to any of the parties, including ourselves, to refer to what's not on the record of these bail proceedings. Of course, during cross-examination, we may want to refer to other things, But the only point I want to make, my lord, is I do not want to agree with my learned friend's suggestion and afterwards be accused of not introducing this qualification.
Mr. Patella?
Not at the beginning of these proceedings today, I sought an understanding from my learned friends pertaining to the area of emphasis of these documents that are being referred to by the witness and led through by my learned friend. We were given, of course, a general comfort that they pertain to the case of Nomangoma.
Sorry?
They pertain, the contents of this file pertains to the case of Nomangoma, which may not directly, at least as yet, affect my client. And therefore, to the extent that the line of answers and questions carries along that way, I would not want to express myself at this stage. But to the extent that it may affect my client, either through the answers that are given and so on, if I have objections, I'll raise them at that stage, my lord.
No, remember what Mr. Litubetsi is suggesting is that looking at the volume of the documents, he would prefer just to hand in the file, you understand, as exhibits, and then he only referred to one or two. That's what his suggestion.
It's his suggestion, my lord.
Yes. And we've heard what Mr. Soni has said, and he says he has no problem with that, as long as it's on the understanding, then that what has not been placed on record is not on record.
Yes, my lord. I would live with that, my lord, as well. But like as I said, the assurance that I was given by my learned friends is that.
Okay, no,
Yes.
we are not yet there.
But yeah, be that as it may, my lord, let me just say, I do not have, subject to that qualification that has been raised by my learned friend, I think I can live with the suggestion of the prosecution.
My lord, I also share the same sentiment as my seniors.
Yes, sir?
That's my seniors.
Oh, okay.
Your Lordship, as the court indicated, it was the state's intention to submit the entire document, the entire bundle as an exhibit. It was just a suggestion in order to save time instead of reading everything. For purposes of cross-examination, they can still cross-examine on any other aspects on these documents which have not been mentioned, because we want to submit the entire documents as exhibits. I just brought this suggestion up for the court in order to save time so that we do not have to read every document before court.
You don't have to read every document. You can identify the document, what it is, and then it gets admitted. But just to submit a file like that becomes almost difficult.
Yes.
Yes. But it's your call to make. How you are going to go about now that you know what the attitude of your colleagues are, it's your call to make.
As it is the court.
Yes.
No, as it is the court, Your Lordship. Thank you. All right. I think insofar as that email is concerned, what is indicated from the last 4 lines of that email?
The 4 last.
From therefore. Okay, maybe for purposes of just this particular email, just read the email into the record. We will deal with the others.
Okay, let me read it as it is
Yes,
for the record.
yes.
You may notice that I am corresponding to you directly without consulting James and Fiti as yet. Until further notice, that is, until I inform you. Please do not share this document. I'm only sharing it with the minister, as he still needs discuss with his counterpart. Please make input into it so that he can understand the deal. I will extract from it something I need to send to my counterpart by Monday. Tentative meeting on Saturday next. Therefore, please look into it and we can converse, or you can simply adjust it. So can print and give the minister tomorrow at breakfast. And by the time I get into the air, we know how to go and we can inform. I will copy them, James and Fiti, on way forward. I trust you understand, Sagi.
Okay, thank you. Your Lordship, perhaps this will be the appropriate time to adjourn with leave of the court. Then you can also just streamline the portions that we want to be reflected.
Yes. It's 4 o'clock. Court will then adjourn until tomorrow morning at 10 o'clock.
As it plays the court.
I must just indicate that this, I have a matter tomorrow, but it's just for determining of hearing dates. So that matter will be called first at 10 o'clock, and then so everybody can set up. That's just a short, but I don't know where. The recording can only start after that matter. It's a very short one. The recording shouldn't record the matter that will be called first at 10 o'clock because there's no application for it. Oh, all right.
All right. Even for one day.
No, he's not. He's not under. Okay, no, then I don't need to warn him. Okay.
All right.